Not like that. Well, maybe when she comes up. I don't know.
Good morning, everyone. We will be starting promptly at 10 a.m. Good morning, everyone. Thank you for joining us on time. I know that there is a lot of people that are just coming in, and I'm sure we'll have a lot more joining us, but in order to be respectful to your time for hopping on time, we're going to go ahead and get started. It is my honor to welcome you to the 2024 Labor Law Update with Schneider's and Associates. My name is Ashley Pope, and I'm the Membership Development Manager for the Ventura Chamber of Commerce. The Ventura Chamber of Commerce is proud to co-host this labor law update for our members and the business community at large. We know that business in California is ever changing and that our business community can only be successful when they have access to accurate information. We would like to take a moment to share our gratitude to Schneider's and Associates for being a firm that our community can trust with their most precious asset, their employees. We want to give a shout out to the Moorpark Chamber of Commerce and SPORE for helping to promote this seminar. The Ventura Chamber of Commerce has labor law posters for sale. If you have not purchased yours already, you can reach out to me directly by email, ashley@ventura-chamber.org. And if you are a member of a different Chamber of Commerce, they are also likely selling posters, so reach out and get in compliance. It is unlikely that we will have time for Q&A today, but we encourage you to put your questions into the chat. We will download them, and someone from Schneider's and Associates will be in touch with you if we don't have time for your questions today. I also have some good news. There's no need to take detailed notes. We will be sending out the PowerPoint after the seminar. And now it is time to introduce our panelists. Attorney Roy Schneider, who hardly needs an introduction, brings more than 40 years of experience to practicing law in the areas of business planning, entity formation, employment law, contract law, estate planning, and nonprofit law. Roy advises and represents companies and entrepreneurs with a broad range of business-related services. Roy frequently speaks before business and nonprofit groups, and Roy is also an adjunct professor at California Lutheran University teaching business law. And we're also excited to welcome a new team member, Sharvani. Sharvani is a law clerk awaiting to take the bar in the February bar, an attorney licensed in India, and a dedicated mediator. She is engaged with working on nonprofits in California, small startups, and large corporate entities, handling their formation, restructuring, partnership agreements, contracts, employment matters, and their transactional and litigation needs. Her expertise primarily revolves around business and corporate transactions and employment mediation. Roy and Sharvani, thank you so much, and I'm happy to pass that along to you.
Okay, well, thank you so much, Ashley. We do appreciate Ashley and the Ventura Chamber very much for helping put this together. This is an important program for everybody listening. We're assuming most of you are business owners, employers, HR people. And I always get a little sad this time of year when we put this program on, knowing how depressed some of you are going to be. But lay off the Xanax and just kind of understand that being an employer in California is challenging. But you are meeting the challenge by attending programs like this, and that's good. One of the best advice I think we can give you at the beginning is look at your employee handbook. That is going to be the source of your advice and where you go with your employees. There have been a number of changes last year and this year that actually requires your handbooks to be updated. Really don't try to do it yourself. Get some professional help. If you'd like us to look at it and give you advice, we would be glad to do so. But the handbook is very, very important. Can't stress it enough. So now we're going to begin with what happened to you guys at the end of last year. Keep in mind that California, like it does every year, enacted over 1,000 new laws, many of which are employment laws. And guess what? You are presumed to know them all. It is never a defense to say, gee, I didn't know that was illegal. So it's incumbent upon you to attend these kind of classes and learn what you need to learn. So wage and hour, that's kind of basic stuff. New laws, as you know, in January 1, which are going to impact your wage and hour practices. Work closely with your counsel, your payroll people to make sure you comply with these new requirements. And here's a little history. As you may remember, there used to be a difference between companies with 26 or more and people with 25 or fewer, and the hours changed. But now, as of January 1, 2024, it doesn't matter your size, the minimum wage for non-exempt employees is $16 an hour. There are exceptions we'll talk about. That's why it's very important that you kind of monitor your remote employees too, to make sure that they are keeping all their hours, keeping track, that when you text your employees at home, there's after-hour calls, that they are marking their time down, and it's a minimum of $16 an hour. Well, also, one more thing, this will increase every year. Legislature can increase it to whatever, but right now it will increase at the lower of CPI or 3.5%, whatever's lower. And if we ever have deflation, where the CPI might actually go down, there'll be no increase in the hourly rates. Keep in mind that a number of cities and counties in this state have what they call living wage ordinances. There's dozens of cities and counties that have different minimum wages going from $16.50 to $19 all over the place. You need to pay attention if you have employees working in any of these areas, that you keep track of what the minimum wage is in those places. And again, this particularly works well for the remote employees. If you have a remote employee in Long Beach, they're going to be paid a different minimum wage than your employees here in Ventura. And so there's also other kinds of wages and exemptions. If you want to have somebody exempt, for example, there may be computer professional employees that you have. These aren't just the IT people. These are people who are software engineers. They are creative, highly skilled, development, program analysts, things like that. That you want to have them exempt from overtime, meals and rest breaks. You have to pay them at least $55.58 an hour. $115,763 annually. Same with doctors. If you have a medical clinic and you have doctors, you want to pay them by the hour and have them be exempt, it's about $101 and something an hour. So those are things to look at specifically if you have questions like that. We will explain this a little bit further about the fast food workers. That'll come in a little later, but they will increase to $20 an hour starting in April. So their wages will go up at the Burger Kings, McDonald's, and so on. Also covered healthcare facility employers, which are many, many huge definitions of what those cover. And depending upon the size and type, their wages will increase in 2024 from $18 an hour to $23 per hour, actually going up to $25 an hour in the near future. So we'll get into that a little bit more later. Okay, so regardless of your size, if you're going to have an exempt employee, exempt from overtime, rest and meal breaks, they must be paid at least $66,560 annually. Monthly, bi-weekly, whatever, must come to $66,560. It's up about $100, about $1,000 from previously. The important thing to note is that even if you have part-time, I'm going to have a part-time CFO, still got to pay them $66,560. It's not prorated, so that's important to note. And remember, your exempt employees, they include, it's not mentioned here, but your inside commission salespeople. That changes too. They get 1.5 times minimum wage, plus 50%, more than 50% of their wages have to come from commission. So you've got to adjust that if that's what you have. But we have the executive, professional, and administrative exemptions. This isn't really the class for that, but just briefly, you should understand that the executive exemption is not just somebody who's supervising some people on the floor. They actually manage and run the business or a distinct unit or division of the business. It's the managers, they run things, they hire, they fire, or the recommendation for hiring and firing is given great weight, and they have independent judgment and discretion. And they have to be supervising, managing at least 2 or more persons. Interestingly, it can be 1 full-time and 2 half-time. So that's an important one. The professional exemption with licensed people, lawyers, doctors, accountants, engineers, optometrists, people like that, architects, or what they call the learned profession. If you have somebody who has particular skill, advanced degrees in science or learning, that takes lots of experience and skill, they may be exempt as well. If you have questions on that, we can talk to you about that. The administrative exemption, people try to use a lot. It's not that easy. They're non-manual labor. They're not doing the work of the business. Not too long ago, insurance adjusters of an insurance company won a huge class action because they were not exempt. They're doing the work of the business, adjusting claims. So it's somebody who assists an exempt person and who basically has independent discretion and judgment and is actually doing some of the work of the exempt person. So if you have questions, let us know. Remember, exempt people have to get 2.5 times minimum wage, and the previous year was about 1,000 less than it is now. Now, this is very interesting in California. Despite all the rules that we have, wage theft in California is still a big deal. People are paid off the clock. They're not paid for their lunch breaks, rest breaks. They're not paid, not given their lunch breaks. And they are not paid for their overtime, especially the lower paid employees, more vulnerable people. So wage theft is a big deal. As most of you know, since 2012, you're supposed to provide a wage theft notice to employees, setting forth the name of the company, its DBAs, address, pay period, workers' compensation information, and sick leave policy, stuff like that. Well, guess what? Now you're required to add a emergency or disaster declaration provision in there. If you hire somebody and there's been a state, federal, local declaration of emergency or disaster within 30 days of hire, you must disclose that. And luckily, the Department of the Labor Commissioner has a form. Can't see it, but it's a form that just came out for you to use as your wage theft form, and it actually has a place for you to put in the information about the emergency, What it doesn't tell us is it has to be an emergency or disaster that will affect the health or safety of the employee. How do you really know that? I mean, my goodness, one man's toxic sludge could be another's potpourri. How are you going to really know that? But nonetheless, you have to disclose these things, which means someone's going to have to monitor this. And even when you have your employees working, if there is one of these emergency or disaster declarations in your state, county, that might affect the health of your employees, you must provide them with a new wage declaration, a wage theft statement, or at least advise them of this new concern. Big responsibility for somebody in the workplace.
Okay. Thank you everyone for joining us. And we'll be now discussing some of the industry specific bills and sort of deep diving into healthcare and food, fast food industries. So first, healthcare. SB 525 establishes new minimum wages for covered healthcare employees. The bill also has broad definitions for what healthcare facilities are. They have definitions for who are these covered employees, and they have really expanded the scope of these coverages. And finally, they have specific provisions for exempt employees and when you can consider employees as exempt in a healthcare setup. And there is a division based on the size of the hospital or the clinic on what minimum wage they have to pay. So first, talking about healthcare facilities. Healthcare facilities are no longer limited to facilities that are just delivering healthcare, but they have now also expanded the definition to medical hospitals, psychiatric hospitals, skilled nursing facilities, home health agencies, and patient homes, if these homes are owned and operated by a general acute care hospital. So patient homes could also be included in this broader definition, but only if it's in the monitoring of an acute care hospital. Moving on to an healthcare employee. Now, an healthcare employee is no longer a person who just works at the hospital, but or a doctor specifically, but they also include people who provide healthcare services and other healthcare providers, such as independent contractors. Independent contractors will only be included under this definition if they have a contract with the facility and the facility directly or indirectly exercises control over the wages, hours, and work condition of the independent contractors. Finally, the exemption regarding the tier division and exempt employees. So healthcare providers can no longer say that an employee is exempt and get away with it because the amount of wages that need to be paid are now more strictly limited. So now the wages needs to be about 150 times more than the prevailing wage or 200 times more than the state minimum wage for an healthcare employee to be considered exempt. Finally, there is a tier division based on the size of the hospital or the number of patients that the hospital or the healthcare facility has. So the first tier is a larger health system where there are about 10,000 full-time employees. And as of June 1, 2024, this minimum wage would be capped at $23 per hour. This will subsequently increase to $24 per hour and $25 per hour, depending on the yearly growth that this industry sees. The second tier is about hospitals where there are about 250,000 patients or people within the healthcare facilities. And their minimum wage per hour, it's not mentioned over here, but it's $18 per hour. And the third and fourth division is more specific to a catch-all provision and a free clinic provision, where these minimum wages are capped at $21 per hour. Now talking about the Fast Recovery Act, as it's famously known. So the Fast Food Minimum Wages Increase Recovery Act has sort of amended the present act where the employer liability has been removed between the franchisor and the franchisee. Now the franchisor and the franchisee no longer share a liability, but and there can be no longer contracts which waive off or indemnify the franchisor against any sort of subsequent liability. And this basically applies to national food chains. Now AB 1228 also provides a definition of what a national food chain would be characterized as. So it's any food chain like your Burger King or McDonald's or something that's operating in California, which has a standard decor option, marketing similarities, packing similarities, and most importantly, allows for off-premises consumption of the foods and beverages and sort of allows for a quick takeaway of these foods. And so the food, so as of April 1, 2024, AB 1228 will repeal the Fast Recovery Act, which was earlier in place, which established a fast food council. Now, what the Fast Food Council did was, in that earlier act, they allowed for the Fast Food Council to set up a minimum wage and then allowed them to have a lot of authority. That was causing a problem. And now the 10-member Fast Food Council has to submit their recommendations before to the Labor Commission before they implement any sort of minimum wage increase or a 3.5% regular increase. Once that is approved, the Fast Food Council can then implement these minimum wages. So beginning of April 1, 2024, the fast food workers will now have $20 per hour as their minimum wage, with an increase up to 3.5% yearly. This law will also preempt municipal corporations from establishing a higher minimum wage for fast food employees, especially if the local municipalities are still permitted under the law to establish a higher minimum wage. But what the local municipality can do is they can establish a higher minimum wage for all the industries, and then that can apply to the fast food industry. But right now it's going to be capped at $20 per hour from April 1, 2024. Another interesting development in the fast food sector will be SB 476. And with this particular legislation, fast food handlers or food handlers in any restaurants, so be it your wait staff, be it anyone who is even touching the food for a minute, they need to have a food handler card. Now, a food handler card is not as easy to get as it sounds. So you need to pass a particular set of course that can be found online on Serve Safe California food handler online. And once you take the course, then you can get this particular food handler card. This is done more specifically to prevent any sort of food contamination, and so that your food handlers are more aware about any of these things going and causing food contaminations with their delivery. What the new legislation does is the cost of these food handler card has now been shifted to the employer, whereby the employer will be paying for the courses that you take, the examination that you will be taking, or the the food handler card that the person will be receiving. So that's about $30 that the employer will need to bear, depending on who is taking the exam and when. And there is another thing that the legislation mentions is that this food handler card will need to be obtained within 30 days of hiring. So the course and the card has to be obtained within 30 days, and the food handler needs to give that particular examination as soon as they're being hired. Talking about the next industry, which is the hospitality and business service industry. So this industry definition also has been broadened, and the amendment sort of increases the term of who a laid off employer was. So during the COVID-19 pandemic, many of the employees were laid off, and this legislation basically increases their deadline from December 31, 2023 to December 31, 2024. So these employees will now get an extra year to be rehired. So what basically is going to happen is that any employee who was laid off during the COVID-19 pandemic for any reason that was related to the pandemic will now be eligible for rehire, and their date of rehiring has been expanded by 1 more year. The legislation has basically done three things. One, they have expanded the definition of who a laid off employee will be, insofar as they have established the particular sentence saying that whose most recent separation from active employment occurred on or after March 4, 2020. So they have given a deadline, and there is a presumption that any employee who was laid off for the lack of business or reduction in force or other non-economic or non-disciplinary reasons will now be presumed to be laid off due to the pandemic. So they don't need to prove that pandemic was one of the reasons that they were laid off. It's a general presumption that now the legislature has established. And ultimately, the deadline has been extended by 1 more year. So in case employees want to seek a rehire with the same company, they can do so under this legislation. Now moving on to leave protection laws, because I'm sure all of us are very interested about the kind of leaves that we'll be entitled to in this new year. So the leave protection laws basically talk about two main laws, one relating to the paid sick leave and other related to a reproductive loss event, which we will discuss after this. So for paid sick leave expansion, what the law did was it modified the California Healthy Workers, Healthy Families Act of 2014. And the law has now two methods of providing for paid sick leave. One is the older method, which is the accrual method. And the other one is a front-loading method, which has now been established in this particular legislation. So for the accrual method, the law remains the same. For every 1 hour work, for every 30-hour worked, the employee will now be entitled to 1 hour of paid sick leave. And this leave can be accrued throughout the year. And there is a maximum cap which the employer can have at 80 hours for a year. So you can accrue paid sick leave up to 80 hours in a year. After that, the leave just lapses. There is no cash out provision, and the accrual method starts again. But what interestingly has happened with the new legislation is that employers will now have an option to give a front-loading leave policy, whereby they can just say that at the beginning of the year, you will get 5 years, which you have to exhaust throughout the year. There is no accrual, there is no carrying forward of this 5 days of leave or 40 hours, and that's that. What they can additionally do is they can have different mechanisms for accruing these leaves, but they have to meet two calendar markings. One of them would be set at the 120th day, and one of them would be set at the 200th calendar day. So by the 120th day, you need to accrue at least 3 days of leave. And if you're going by a different method, and by the 200th day, you need to accrue at least the 5 hours sick leave. So basically, these are some of the two methods in which you can give your employees the paid sick leave. And the front loading mechanism has now been established, whereby you have 40 hours flat out or 5 days flat out, which they can incur throughout the year. They don't need to show a particular cause or give a reason as to why they are going on a sick leave, but that's capped at 5 days. Interestingly, this sick leave can also be used along with any other accrued leaves for a reproductive loss event. So this applies now to a new legislation which came up with something called as a reproductive loss. The legislation under SB 848 has defined what a reproductive loss event would be like. And it basically means the final day of a failed adoption, a failed surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. So the 5 days of sick leave can now be used for a reproductive loss leave, because you get 5 days for a reproductive loss event. Interestingly, you don't need to take the 5 days at one go. The legislation now provides you 3 months, and you can take those 5 days scattered throughout the 3 months. Due for any reproductive loss event, the law limits that during 1 year, the maximum that you can take for a reproductive loss leave would be 20 days within the 12-month period. So if there are multiple reproductive losses, the leaves are capped at 20 days within the 12-month period. And the leave again there's no necessity to take it at one go, and you can just take it as you feel like in a 3-month period.
Okay, are your heads spinning? I hope not. If you need more information about the food handler card, that is something you can contact us if you have a restaurant and don't know about it. We've found that most employers prefer the front loading of the sick leave, but that's kind of up to you. Keeping track of 1 hour for every 30 is more bookkeeping, but that's up to you. If you have more questions on that, let us know. We can help you. The next is California is, as it often is, first in the nation to come up with a workplace prevention, a violence prevention program. And that is SB 553. This is brand new. It adds to the labor code. It is a huge deal, and it affects all California employers, except a few, and I'll go through that. You must maintain an effective workplace prevention violence prevention plan by July 1, 2024. And workplace violence is defined as any act of violence or threat of violence that occurs in a place of employment. And it can result in a high likelihood of resulting in injury, psychological trauma, or stress, even if the employee is not injured. Now, it's not a likelihood of injury or psychological trauma, a significant likelihood, but a high likelihood. Can any of you know what a high likelihood is? Of course not. This is another example of the legislature putting in words, like a word salad, that we can have to figure out what it means, because you're not responsible for a likelihood, just a high likelihood. And this can come from any employee, can come from customers, vendors, disgruntled spouses, significant others, any third party can create this workplace violence. It can be on social media, Facebook, Instagram. It can be a direct text, an email, a call. It's a very broad definition of that, which is interesting. And no injury is required. Okay, so under the new law, you are required by July to come up with this workplace violence prevention plan. Interestingly, Cal OSHA was tasked with this project to be completed by 2016. It never did it. It did come up with a workplace violence prevention plan for the healthcare industry, and they're one of the groups that are exempt from this, but they've not come up yet for the average employer. So the legislature said, screw that, we're going to come up with our own rules. We're going to require Cal OSHA to implement its regulations by the end of 2025, and to have them ready to go and handed out and enforced by 2026. But we're going to go ahead and set forth the parameters. So right now, this is the law. And so your plan, you can include it in your illness injury prevention plan or a standalone. You've got to include 13 different things in it. And here's just a few. Obviously, the person responsible for implementing the plan. Also, interestingly, again, you're supposed to come up with a mechanism that involves your employees in coming up with the plan, because your employees who are working in the field or working in the dimly lit areas or on dangerous job sites, they know what might be more subject to violence than you might, so they need to be involved. And you've got to also evaluate, identify, and correct any workplace violence hazards that your employees or you may come up with. So you need to do kind of an audit, and it has to be training, which I'll talk about in a minute. There has to be a method to respond to these reports of workplace violence. What are you going to do if somebody makes a report? And there's no retaliation against any employee who makes a report. The training we talked about, how you're going to correct workplace violence in a timely manner. Post-incident response, Procedures to review and update the plan annually. You must review and update this plan annually or after any incident of violence. Firstly, covers all employers. A few people are exempt, for example, healthcare industry, because they have their own Cal OSHA plan. If you have less than 10 employees at a site that is not accessible to the public, you're exempt. And actually that covers many offices. If you have an insurance office, financial planning office, some office, law office, accounting, that's not accessible to the public, and you have 9 or less employees, you don't have to do this. Also, employees who work off-site at a workplace of their own choice, without any control by the employer, they're exempt. So if you have an employee that works from home or at a Starbucks, you may not have to cover them under this thing or be included. So you have to keep, they mentioned this workplace incident log, which is problematic every time there's some kind of an incident. You're already required to report to OSHA, Cal OSHA, any serious injury or death in a workplace. But this is any kind of violence we just talked about, any threat that is highly likely to cause stress or trauma. Got to put the date of the and time, type of workplace violence, whether it's sexual assault, battery, yelling, text, description of the incident, what exactly happened, a classification of who committed the violence. This is also kind of odd. You're supposed to leave out identifying information. You can't say Sam yelled at Mary. Got to leave the names of the people out. But I can see that as problematic if you say, well, the floor manager, and you got one floor manager. Nonetheless, you're not supposed to have identifying information in the violence log. What were the circumstances of the incident? Was it a lowly staffed, a single worker, low light, alcohol present, serving alcohol? You got to kind of describe the circumstances. The type of incidents, a physical attack, sexual assault, consequences. Did somebody call security, law enforcement? And also information about the person completing the log. So this will be helpful, hopefully, in coming up with this plan. That there should be some sort of guidance, hopefully for July, by the Cal OSHA or by the Labor Commissioner. But if not, we certainly and others can help you prepare these plans. Very important. Yes, one of the interesting things is you got to provide training on an annual basis. So you got to provide the training when you first implement this plan and every year thereafter, and also for new hires. So you should consider going through the violence prevention plan with your new hires. Okay, and then you just do annually. You must keep your records of the training 1 year. And actually the records of your plan, incident logs, and so on must be kept for 5 years. Our Cal OSHA is free to enforce this. They can do spot audits. Somebody can file a complaint with Cal OSHA. There can be a log where somebody seriously injured has been filed with Cal OSHA. And if you don't have a workplace prevention plan and incident logs, there can be penalties. And the penalty for a serious violation is $25,000. And Cal OSHA has definitions, OSHA has definitions for serious, up to almost $154,000 for willful violation. So if you just say, we're not going to do this plan, we're not going to keep any logs, and you get audited by OSHA, federal or Cal OSHA, you may pay $154,000 in penalty. So this could be very serious. Pay attention to this. This is something you really need to work on. And it's going to cover all employees except the few that we mentioned. So this training that you have, when you go through all the 13 points that's going to be in your workplace prevention plan, but the key is, let the employees know how to obtain a copy for free, how they're supposed to report the incident and who they report it to. Should they report to law enforcement? Certainly, how they do that, have the numbers available. You want to also describe all the hazards, workplace violence hazards that might be related to that person's job. and what corrective measures you have implemented, and request these employees over and over again, what can we do to make you safer? Especially for employees who are working alone or in dimly lit areas, or even making calls outside. Those are all workplace, and it could be very, very dangerous for them, so they should let you know. And you can't prevent all violence, but you have to let people know what the hazards are, how you're going to fix it, and keep records of it. And again, when you do this training, it should be interactive. I mean, sure, there'll be some organizations that will set online training for people. Online trainings don't work really very well. We've seen that in the sexual harassment prevention training. People are multitasking, not paying attention. But this has to really be interactive. So you want to plan on those trainings. Okay, so I told you we got to keep the training information for 1 year and the records of the incident logs, workplace violence investigations, and your hazard identification, evaluation, and correction, detailed information you have to keep on record for 5 years. And if you're audited, you really want to have those available. So that's something to really, really think about. Okay, so yes, so as I mentioned, you have to make these records available. So if the California Division of Occupational Safety, CalOSHA, request copies of your workplace hazard stuff, you got to send it to them. Training records, and you don't want to be scrambling, putting together to answer the letter. And they will begin enforcing this on July 1, 2024. And they'll have its own standards by the end of 25 and adopt the standards by 2026, but they will be along the lines of what we've just discussed. Also, this is kind of similar, kind of goes in the same vein. As you may know, employers can go to court and seek restraining orders regarding threats of violence to their employees. Now, SB 553 now allows basically union representatives to go ahead and seek these restraining orders, even without mentioning the employee's name in court. But I don't know why they wouldn't. But yeah, it is very important. It can keep ex-employees, former employees, disgruntled, significantly others from harassing and from actually threatening violence on an employee. And the restraining orders can keep these people away from the workplace, away from the person's home and their family, and it's quite useful. However, it hasn't covered harassment. And so starting in 2025, and we'll learn about that next year, employers will be able to get restraining orders, temporary restraining orders, to protect their employees from harassment, as well as physical threats. And the case that brought that to the attention of the legislature was a 65-year-old man who was harassing a 23-year-old employee, young woman. He would stop by the workplace, he would text her or call her 100 times a day, annoyed her, but no threats of violence, nothing. But therefore, there was nothing the employer could do. Now, starting in 2025, the employer can get a restraining order to prevent someone from harassing its employees at home, at the workplace, and their family. So that's a big thing to pay attention to. But right now, you can get a temporary restraining order for threats of violence. You know, this is also good, as you may know, defamation. Certain things that you say, defamation is something that can be written, which is libel, or verbal, which is slander, and it tends to ruin somebody's reputation. We have all kinds of privileges. There's newspaper privileges, public figure privileges, and there are privileges to talk to people who are interested in knowing things, like your employer, or maybe close colleagues or your family, about sexual harassment. But now they've expanded the defamation privilege under Assembly Bill 933 to include talking about incidents of sexual assault, harassment, or discrimination, not just sexual harassment, but assault and discrimination without malice. And that's the key to all these defamation defenses. It has to be made without malice. It has to be based upon credible concerns that you've had that could back up with some evidence. And you're not allowed to make things up. And the big thing about this is also you can talk about people who assisted, aided, and abetted in the discrimination, the assault, the harassment, people who tried to cover it up, be protected from defamation, people who incited it. So the privilege is now much broader, but the most important thing about this new law to keep in mind, and employers and managers and so on to keep in mind, is that previously, if you were sued for defamation, there was no, you had to defend yourself, and there was no attorney's fees, and it was very expensive, and many employees just couldn't afford the defense, and they would just cave in. Now, if you were sued for defamation under one of these privileges that you can assert, you're entitled to your attorney's fees if you prevail, damages that you've suffered because of that lawsuit, damages can be tripled, and you get your attorney's fees. So it's a big deterrent, hopefully, from people in your company who have resources suing those who don't. So that's an important one. If you have more questions about that, let us know.
Okay. Moving on to Equal Pay and Anti-Retaliation Protection Act, which has now been amended from SB 497. So earlier, under the Anti-Retaliation Protection Act, the Labor Code, Code provided for three kinds of prohibitions against retaliations. So one being prohibition against retaliation for employees who file wage claims with the Labor Commissioner or under PAGA. There is a prohibition against retaliation against employees who report violation of the law. And there's a prohibition against retaliation against employees who bring up concerns related to California Equal Pay Act. So earlier, in order to prove that there was a retaliation and that retaliation was connected with a protected activities, there was a three-step process that had to be completed. And it was famously known as the burden shifting process. So first, the burden fell on the employee. Second, the burden fell on the employer. And third, again, the burden fell on the employee. So for earlier, the law required that an employee who was claiming that there has been a retaliation had to show that they engaged in a protected activity. Then that particular activity resulted into an adverse action against them. And thirdly, there was a causal nexus between the employee's protected activity and the adverse action. What the new law does is that it completely removes this first step where the employee needs to build their prima facie case, and it gives the employee a rebuttable presumption for 90 days that if any adverse action was taken against them and which against an activity which was protected, there is a rebuttable presumption for the first 90 days only that there was a connection between these two. So for example, if an employee who complained of an unfair wage or as compared to her male employees was laid off in 2 months from such a complaint. So earlier she had to prove that this particular complaint that she made and the action of laying her off were connected, and that is why she was laid off. But now the law provides you with a 90-day window of saying that there was a connection, and then the burden directly shifts on the employer to prove that there wasn't. And if the employer is able to prove that there wasn't, then the employee again has a burden to show that there still was a presumption. And then the court sort of goes on to analyze from there as to what really happened. The new law also increases civil penalties per employee for each violation. So if there were several violations of several protected activities, the employee will now get $10,000, up to $10,000 in civil penalties for each of these violations that they were affected by. What the law also does is, interestingly, it also includes a provision whereby if a coworker communicates with another coworker about their pay or about their salary, there can be no retaliation that they can be faced with. So they're free to discuss their salaries and free to discuss on what each of them is getting and maybe bring it up with their employer if there's such an issue. And there's no retaliation that the employee can be faced with. Moving on to dispute resolution, and California has done itself over here with going against the Federal Arbitration Act. And in a landmark decision, they have now said that there is no automatic stay during appeals of motions to compel arbitration decisions. So earlier and as is the Federal Arbitration Act, whenever there was a trial and there was an arbitration clause in the particular contract, and so one of the parties moved court, say, with a motion to compel arbitration, there was an automatic stay that was put up on the trial. This is no longer the case. The trial will continue and the motion will be heard simultaneously. If the motion is granted, then then the court can stay the particular proceedings and that will go on to arbitration. Additionally, this law also allows the trial court to grant these stay orders at their own discretion, but this is no longer an automatic stay that there's no longer an automatic stay that will come up if there is a motion to compel arbitration. So this goes against one of the most important cases that relating to the Federal Arbitration Act of Coinbase Inc. The Coinbase decision basically said that if there is an appeal and there is a motion to compel arbitration, there is an automatic stay, and this is done so that the costs of litigation can be saved. But California has now moved against it. A problem that we foresee in this area is in those contracts, especially where there is no provision for a governing arbitration act, or there is a Federal Arbitration Act provision, and there is no specific provision as to implementation of both the statutory, both the substantive and the procedural provisions of the Federal Arbitration Act. So what the California courts will now need to do is they'll first need to examine as to which law the contract is governed by, whether it's the Federal Arbitration Act or it's the California Arbitration Act. If it's the California Arbitration Act, this will automatically go on the new law, and there will be no stay that would be granted for any motions to compel arbitration. However, if it's a case of Federal Arbitration Act, the case will be a little different. The court will now first need to examine as to whether the Federal Arbitration Act has been implemented substantively and procedurally in the contract. So what it means is that whether protections under the Federal Arbitration Acts have been granted essentially in the contract provisions. If that is the case, then the contract and the case hearings will be according to the Federal Arbitration Act. And if either the substantive or the procedural part is not implemented into the contract, the case will now be directed directly in the California Arbitration Act. This is going to cause a lot of chaos, especially given some of these contracts that are currently in place whereby there is no governing clause. So you may want to look at amending some of the contracts that you have with your employees and providing for a more substantive and procedural implementation of either the Federal Arbitration Act or the California Arbitration Act.
Okay. Yeah, the federal courts have taken the position that the Federal Arbitration Act governs so many of these things. This new law will be litigated. Maybe it'll go to the U.S. Supreme Court at some point. You have to decide whether you want to be the test case or whatever, but that is California's effort to help employees, because usually it's the employer who appeals the decision not to allow arbitration, and that obviously puts a burden on the employee. California was the first state in the nation to invalidate agreements not to compete with your employees. California is the most pro-employee mobility state in the country, although that is changing. Other states are catching up to us. You're all familiar with what a non-compete agreement is. It's simply originally under Business and Professions Code 16600, which simply says, except as provided in this chapter, every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. Lots and lots of cases had to deal with that and decide what that really means. And despite this public policy, despite this statute, California employers continue to have employees sign non-compete agreements, covenant not to compete. A lot of lower wage employees and vulnerable employees, and California employers continue to engage in frivolous litigation to stop them from competing. And the employees really have a hard time defending. And these are all post-termination matters. They're no longer considered employees. So now there is some new statutes, new teeth to this, added some new sections that said any contract that has provisions that's non-compete for an employee, it's void and unenforceable. Also, wherever it was signed and implemented, so an employee might have been an employee in Wisconsin, where these kind of provisions are non-compete or valid. They signed it there, they worked there, but they moved to California, and now it is no longer valid and enforceable. And we see situations where people have signed these contracts, they agree to be governed by the foreign law, they quit their job, move to California, get a job with a competitor, they get these threatening letters, and then we have to advise the company in the other jurisdiction, it's not enforceable here, plus you have now potential damages that you can be liable for. Basically, these things are not brand new really in California to some extent. They reflect public policy ever since the 2008 case of Arthur Anderson, Edward versus Arthur Anderson. And it says the statute, no matter how narrowly drawn this covenant not to compete is, it is invalid. In that case, somebody left a big accounting firm who had thousands of clients, and the agreement said, you agree not to do work for this one client. Very narrowly drawn, it could still be an accountant, but the court said that's invalid. So now the statutes have now made it statutory, not just public policy. So this is now a civil violation for entering into. Employers may not enter into covenants not to compete. They may not encourage it. They may not discuss it with their employees. They may not ask their employees. And what is different in the past, when there was this covenant not to compete and someone is going to quit and go work for a competitor, they would have to bring, there was no affirmative cause of action. There was no affirmative right. They'd maybe bring a declaratory relief action in court, asking the court to determine if this clause is valid or not. But now, the private cause of action, employers are firmly prohibited from entering into these things. It void against public policy, and employees can bring a lawsuit anytime to say these are invalid, this is enforceable, and they can get injunctive relief against their employer or former employer. They can get damages if they've suffered any damages, and attorney's fees, which is a big deal for post-termination people to get their attorney's fees. So it is a big deal. Employers should go through all their contracts and make sure that they don't have these in there, anything about covenant not to compete. What is uncertain is non-solicitation. A lot of you may have contracts or agreements with your employees that if they leave, they will not solicit your employees, right? Well, we thought that for years and years that was permissible. By the Sixth Circuit had a case and said it was permissible in 2007 or 8, 2005. But then in 2019, the Fourth Circuit in California said no, those kind of non-solicitation are invalid because it doesn't affect people's rights to get jobs. California Supreme Court hasn't dealt with it yet. So if you want to have non-solicitation of employees, give it a lot of consideration. Also, what this now covers is people can enforce these non-compete agreements, even if they're not parties to it. For example, if business A has a contract with business B, where they both agreed not to hire each other's employees, that's unlawful. And anybody affected by that can sue. The unanswered questions are, and it's very common, you have an independent contractor and you have an agreement saying you're not going to go solicit our employees, or you have an independent contractor go out to a job site and you're going to tell your person that you're having the contract to go to, you will not hire him as him or her as an employee. All those things are in question now, and we'll have to deal with those. So give a thought. The other big one is if you've entered into any kind of non-compete agreement on or after January 1, 2022, as an employer, you have an affirmative obligation to send written notice by February 14th of this year to let them know that clause is invalid, void, unenforceable. And you have to do it in writing and send it to their last known physical address and email it to that former employee. If you don't do that, that's a violation of California's unfair competition law, and you can be liable for that, and that can be very, very serious. Next. Okay, this is a big win for employees. Prior to this 594, wage and hour violations were prosecuted by the Division of Labor Standards, the Labor Commissioner. They were the ones who could bring actions. Well, they're overwhelmed. Too many people. You may know employees file, you get a right to sue letter, and then they can go sue themselves. But it is obviously to their advantage, less expensive. It's easier to just go through a labor commissioner. They're overwhelmed, can't do it all. So this new law will empower any public prosecutor, Attorney General's office, District Attorney's office, County Counsel's office, City Attorney's office, to bring a claim against an employer for wage and hour violations, and makes it criminal and civil penalties. So you don't have to limit yourself to the Labor Commissioner in California. Any of them can do that. And if you have an agreement with your employer that limits your claims to arbitration, that's not binding on law enforcement. Or if it says you can't represent anybody in a representative capacity, no class actions, that's not binding on these prosecutors. They can bring actions on behalf of one or many employees. They collect wages that will go to the affected employee, and the civil penalties that are charged will go to the general fund. So this is a big deal for employees, huge.
We'll discuss more about some of the updates which are now not classified into these categories, and some very interesting updates with regards to testing. So earlier, drug testing or testing for use of marijuana or cannabis was prevalent, and that used to be one of the criteria for either selecting or hire or fire decisions. But the new law, which explains or sort of builds up upon an earlier AB 2188, now provides that except for workers working in building or construction industries, there can be no testing that can be done using hair or urine samples for marijuana traces. The reason that this is happening is because marijuana traces can remain in the body from up to 1 day to 1 week. So it doesn't really give a clear picture of whether the employee was using these particular substances either prior to their employment or after. However, what the law clarifies upon is that other testing mechanisms, such as blood sampling, can be done if the employer needs to verify or do a drug test screening. This does not also prohibit the employer from discriminating in hiring based on a test known as the non-psychoactive cannabis metabodies test. So what that will do is that will give you a level of the presence of marijuana in your body, and that is sort of prevented. That you cannot use the results of those tests in order to establish a hire or fire decision or discriminate on the basis of these particular test results. But you can still do it in order to ensure health and safety, but only through specific blood testing. And that will be more limited in the sense of giving the true picture of what is happening on the job. Also, none of this applies to anything that workers are engaged with in building or construction industries, again, or where the health or safety of the customers or these people or your other people will be affected because of these uses. Secondly, we will be discussing more about the case developments subsequently, but just to give a broader picture about what the definition of employer will now include. So an employer is no longer someone who is directly your employer, but that also now includes a business entity, agent, or a third party. So interestingly, in the case of Reigns v. U.S. Health Work Medical Group, the Ninth Circuit asked the following question: does California's Fair Employment and Housing Act, which defined the term employer, include any person acting as an agent of the employer's permit, a business entity acting as an agent of the employer to be directly liable for employment discrimination. The Supreme Court has now clarified on this question, and it has said that any business entity agent can be held directly liable under FEHA for employment discrimination. So now the definition of employer has been expanded, and Roy will deal more with the case law and about the facts that led to this particular legislation. But now it also includes your third-party business entity agents. Moving on to one of the interesting cases that recently happened with Apple. Some of you may be familiar with Immigration and Nationality Act anti-discrimination policy. So this policy basically provided for a PERM certification, which meant permanent labor certification, which allowed for hiring non-US applicants by giving them work permits in the United States to work on certain jobs. In order to be qualified to get a PERM certification, an US applicant, the company would need to have very specific steps in order to hire a non-US applicant. So earlier, the company would need to have these advertisements. They needed to call for applications from US applicants. And then if there were no applicants that were suited for the position, only then could this position be awarded to a non-US applicant. And a PERM certification, which is the permanent labor certification for residency, can be sought for these non-US applicants. What happened interestingly with Apple was Apple is now being liable to pay a $6.75 million in civil penalty and $18.25 million as back pay. What Apple did was they wanted to hire a lot of non-US residents, and in order to get away or get around this PERM certification requirement, Apple simply posted these job openings on their own website and not on any other third-party website, which they usually posted their job listing on. So any job at Apple could only be viewed in the Apple portal and not on, say, maybe LinkedIn or Monster.com or Indeed and whatever third-party websites exist. Another thing that Apple did was they called for these applications in a paper form, whereas usually now the application process is very simplified and you can just apply to any job opportunities online. However, since they wanted to hire specific people who are of non-US origin, they made it harder for people to apply for these positions. As a result, not many applicants applied and not many people even made it through the interview rounds. This was discovered by the Labor Commission and now they're being made to pay a hefty fine. So you should be sure before offering a position to a non-US citizen that you have put up advertisements through different portals, made it easier for people to apply for these positions. And if you do not find a suitable candidate, only then can you seek a PERM certification for non-US citizens to apply.
Thank you for sticking with us. We've just got a few more minutes and we'll be finished. There's some new cases that I just want to bring to your attention. You can contact us if you need more information. One is the one that Sharvani talked about. This reigns interesting, as many of you do. Companies, after they hire someone, a condition of employment will be going through a healthcare screening. Here, they went through this U.S. Health Works Medical Group. They had a screening. The medical group there was asking all kinds of questions, personal, invasive questions. The employees, the applicants said, I'm not going to answer that one question. They stopped the screening, told the employer revoked the offer, and this applicant sued the lab testing, the medical screening place. And they said, we're just agents, so we're not responsible. You have to sue your employer. And the court said, no, if you have 5 or more employees yourself, you are governed by the Fair Employment and Housing Act. You, healthcare screening company, did the discrimination. Therefore, you are liable as an employer and all the penalties and civil penalties and damages under FEHA. So very important to keep that in mind if you're doing anything for employers, background checks, and so on. The next case, this is traditionally, as you may know, in the areas of sexual harassment, companies are strictly liable if a supervisor, manager sexually harasses an employee. Strict liability, basically is just a question of how much you have to pay. This is the difference. This actually is a little benefit for the employer. This was a bunch of a district manager and a pharmacist having contact. They had, and she sued. The pharmacist sued for sexual harassment. I guess it just got too far, but the court relied on all kinds of evidence showing that these people had texted about family, vacation, dining, alcohol, drinking, exercise, chit chat. They met often for coffee, they met for lunch and the holidays. And they determined that there was no strict liability here because the harassment, one, occurred outside of work, which is not always the defense, but that the pharmacist was a willing participant, that she was more than happy to go back and forth. Eventually, she wanted to call it off, claim sexual harassment, but she can go after the potential guy who harassed her, but the company is protected. It's a good case.
So this particular case relates to the employment contracts that you may have with your employees and sort of gives you a picture of why you shouldn't be recycling those contracts. In this particular case, the plaintiff had signed an employment agreement with Employbridge LLC, defendant, and the employment contract provided for a dispute resolution mechanism. In this mechanism to arbitrate, the contract specifically carved out certain provisions stating that any claims under PAGA are not arbitrable under this agreement. This is contrary to the law that was in place with regards to a very famous ruling in Viking Rivers, and whereas in which Viking Rivers provided that any individual claims under PAGA can be referred to arbitration. So the employer basically reused a particular old contract and had this carve-out provision. As the case may have it, this case went under an individual PAGA claim, and the defendant asserted their Viking Rivers rights, whereby they stated that since this is an individual PAGA claim, it should go through arbitration. But the court held that since there is a carve-out provision which specifies that claims under PAGA are not arbitrable under this agreement, they will not be arbitrable under the agreement. So the court gave the weightage of this particular contract more importance than any other ruling and sort of had a clear picture on to draft your contracts very carefully when you want to arbitrate certain kind of disputes, or just have a catch-all provision saying that any kind of disputes that come out of this employment contract would be referred to arbitration. This so this particular case is currently pending its review. It's Castellanos versus State of California. It's been building up for quite some time now, with many cases that built up to this particular decision. Give a background of this particular case in the Dynamics holding, which happened a few years back in 2019. The legislature enacted AB 5, which distinguished between employees and independent contractors. The distinction was narrow and avoided for complicated exceptions. And this was challenged subsequently by Uber and certain drive-through apps when the state of California brought suit against these apps, saying that they are classifying their employees incorrectly as as independent contractors. It is important to note that classifying an employee as an independent contractor is a major violation. And so this case got a lot of limelight. As a result of the case, the Uber and Lyft and some of the app-based companies, they came out to the California voters and voted for Prop 22, which is the basis of discussion in Castellanos. Prop 22 made certain guarantees to provide for this classification, and thereby mentioned that the drivers or certain employees who were employed with the app-based services would be considered as independent contractors. And in return for classifying them as independent contractors, they were guaranteed 120% of minimum wage for active driving time, a partial health care, subsidy benefits, and this particular legislation was passed in November 2020. However, the legislation is under review, and the recent judgment held that Prop 22 unconstitutionally, the recent judgment was about discussing whether Prop 22 unconstitutionally limited the power of California legislations to grant the right to organize or give access to state workers' compensation. The court has currently upheld Prop 22, but it is still under review with the California Supreme Court.
That is a significantly key case for anybody who uses the drivers or DoorDash people. I mean, that's big. Proposition passed by 58% of the people, but it may be unconstitutional. The last case is somewhat of interest, is the ministerial exception. After the Civil Rights Act of 1965 or 64, we had a question about the ministerial exception, dealing with churches and temples and mosques and so on. Are they exempt from the FEHA or Title VII discrimination claims? And the courts, Supreme Court, other courts have held that when it comes to the ministers, rabbis, priests, imams, church leaders, pastors, the internal workings of the organization have to be left alone. The First Amendment of the Constitution for exercise of religion prohibits the state from really regulating that. But over time, the idea of a minister expanded way beyond the clergy. To any teachers, the people who have some religious training themselves and impart religion, do religious stuff. It has applied in cases to religious hospitals, schools, religious institutions. The definition of that is beyond this. But the question here was, this was a 40-year employee. She had agreed to, live her life and conduct her life according to the teachings of the Catholic Church, to make sure that her students, people she dealt with, acted in Christ-like manners, whatever that meant. She was an office worker and an art teacher. Nowhere did she teach religion, encourage religion, deal with religion as she was an office worker. She was essentially terminated after 40 years. She brought an age discrimination case. The lower court said, they determined that she's in a religious setting and ministerial exception applies. They can discriminate against her. The Court of Appeals said, no, you know what? There's enough facts here to look at. We're not going to just give them a summary judgment that her duties had nothing to do with religion. She didn't teach the kids anything. She didn't lead them in prayers. She had no job duties. So the lesson here is, if you have a religious institution and you want to try to avoid the laws against discrimination, whether it's race, religion, sex, whatever it is, you must have detailed job descriptions saying that they need certain kind of religious training, or that they'll be imparting maybe religious views, or there'll be something. Otherwise, you may find your institution subject to claims against discrimination. That is big. Those kind of cases will continue. Okay, well, that concludes our presentation. We went 15 minutes over. I'm sorry. I hope you found it interesting. You may have questions. Please chat it or email us, and we will definitely respond. And again, thank you to the Ventura Chamber again for putting this on.
Thank you. Great presentation, and have a great day, everyone.